The judge has refused Kohberger's defense motion to stay the trial, so they're going to continue to have the trial scheduled for October of 2023 this year. That's in less than 2 months, which is wild to me. I honestly thought, there was going to be some issues and it was going to be delayed. But I mean, we'll see. There's always a chance that it could still be delayed for some reason. But the judge is going to have it. So it's set for October of 2nd, 2023. And they're going to have jury selection about a week before. Yeah, that's wild. When he came into the courtroom. Now, this footage, shout out to Law and Crime. We're not going to watch in its entirety. These are the different experts that will testify. But I was wondering, who was Kohberger smiling to? He walked into the courtroom and he smiled at someone. So I wonder if he's like a family member that's back there, someone that he knows, or is he just smiling just to smile? And there's really no one back there. I don't know. I was like, who is he smiling at? Does anyone know? The plan with X, create everything app, including messaging, payments, etc. Oh, interesting. Defense is accusing the state of not turning everything over. The state's like, listen, we've turned over everything that we can, the stuff that we need to turn over at least. But there's nothing else that we have to turn over. I mean, maybe there's some things we miss. And the judge is like, hey, I want to make sure we don't miss anything because, this is a DP case and, they don't want to have to go through the appeals and realize, oh, my God, the state didn't turn over this. They didn't turn over that. So the judge wants to make sure, everything's turned over. Things that are supposed to be turned over needs to be turned over. And defense is like, yeah, we don't have this. We don't have that. And so they're just kind of arguing back and forth. So I do want to listen to that part really quick and I will.
One point of clarification, it occurred to me while listening to the court talking about genetic genealogy and really that being a focus. There are a couple of other areas contained in the motion to compel that have to do with the other DNA that the state doesn't have complete discoveries to us that are included in that third motion to compel that are up for today. The big focus is then the genetic genealogy piece, but I wanted to make sure that was still in scope.
Well, my understanding was that the state did provide all the information about the laboratory, we'll say the laboratory DNA that was, that analysis was not related to the genealogy DNA. Am I mistaken about that? What are you saying that they didn't provide something?
Your Honor, in our third motion...
No, I think so Law and Crime should up their game with shotgun characteristics microphone. I think it's probably something what the judge allows and doesn't allow. The judge is probably just like, hey, court TV, whatever it is, whoever's doing the recording, you can bring your camera, but don't be bringing anything else that might be distracting. Because I think otherwise they would probably up their game, of course, and try to get really good audio. It just depends on the judge, remember the Letitia Stout case? That one was really hard to listen to because it was all webcam quality. It was all webcam quality. And we're just at least that one, though, I think had decent audio, though. I'd rather have decent audio and crappy video than vice versa. I don't know. I think the audio is just so important. Letitia's frame movie quality. Yeah, I think it's just dependent on what the judge allows. Because, I'm sure, when they want good audio too. They want good quality too. They want to make sure everything gets picked up. So, yeah, I don't know.
We had
that's what I'm assuming.
Lab discovery, and that has to do with other DNA profiles found at the scene. They have provided full discovery for the sheet, the DNA found on the night sheet, but not the other 3 unidentified male DNA samples. 2 from within the house, 1 from outside.
Okay, so now Kohberger's defense is asking about the other 3 unidentified male DNA samples that was also found within the house. And I think one was found outside of the house as well.
All right. So if I'm understanding your question there, or your assertion that we're talking about 3 potential analysis of DNA that was not provided to you, but that has no connection to Mr. Kohberger.
Correct.
Any response?
Your Honor, we didn't realize this was going to be an issue. We had given the defense everything that we received from the lab. They'd asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist.
Okay, and he's saying the DNA, there's no DNA workup done on those 3 people. So maybe I don't have to just transcribe him because obviously the camera's closer to the state side so we can hear them pretty fucking clearly.
We provide everything. There's one outstanding lab report that relates to the forensic examination by the lab personnel at the crime scene itself will be received today. That's the only outstanding lab report. Everything else, along with all the notes, is what there is, and it's been provided to the defense. And if they're hoping that there's something else there, it's not there.
Okay.
Taylor?
Well,
Speaking of potatoes, my family came up from Idaho. They brought me back some potatoes the size of my head. What? If you're at the Discord, I would love to see those potatoes. Post it in the Discord.
Your Honor, as part of our third motion to compel, it's still something that we don't have. We also don't have the unexpected corrective actions, unexpected results from the Idaho State Police Forensics Lab for the 6 months before and the 6 months after November 13th, 2022. We did get some, but it's a narrow scope, and we asked for the full year, 6 months before and 6 months after. That's also in our motion to compel.
Sure. I understand your responsibility is to turn over every rock, but you can't get things that don't exist as well. So, I mean, there has to be some level of trust in discovery. You're all sworn attorneys. And so Mr. Thompson is saying that there's one more lab report that is coming your way today, I heard him say.
Maybe not today. We were waiting to receive it so that we can process it for discovery. It's supposed to be in any time.
Okay, I misunderstood that. So it's coming soon. It has to come soon because we're 6 weeks away from the trial. So
Wow, 6 weeks away from trial. Isn't that crazy, y'all?
I don't know what exists that we haven't received. We provided all the requests to the lab, and they've assured us that they have provided us with everything they have within the scope of those requests. I'm not sure what else to say. I mean, we can make a supplemental inquiry to clarify that after we finish the report today. But I'm kind of sitting here saying, Judge was giving me everything we know to exist.
well, that would be wise to check on that.
We will.
Because we don't want this to come back on the eve of trial.
Yes, sir.
Or, 4 years from now at an appeal.
Yes, sir.
So we want to make sure that we have combed through all the information that has any bearing or argument of bearing on this case. That's all.
Ms. Jennings is making a note right now. We'll send the inquiry out later today.
Okay.
Thanks, sir.
Okay, so the recap with that, and Taylor saying they haven't given us everything. They're saying, the state is saying, we gave them everything that we have. I mean, maybe I can make some supplemental inquiries to see if there's anything we missed, but we've given them everything that we have. And she's saying, no, they didn't. The judge is like, well, there has to be some level of trust and discovery. Like, you guys are both sworn in, both sides. You guys are all sworn in lawyers, attorneys, so yeah, I don't know. She doesn't think they turned everything over, and they're saying that they did turn everything over.
This circumstance, we also ask for all emails, text messages, a lot of electronic messages or other messages. Some have been provided, but we don't have assurance that that's all. And so for the same reason, we want to make sure that we have the complete file.
Okay, Mr. Thompson.
We have told them, we have given them everything that we know to exist. And that's the lab
This guy's like getting frustrated.
provided to us and sent to them. At this point, all I'm hearing is speculation. They think maybe or they wish something else was there. But as far as we know, it doesn't exist. I don't know what else we can say. You can't respond to something that isn't real. Sorry, Judge.
We're just sorting it out.
Yes.
I'm hoping he does the opening statement.
Sir.
Making sure that everything that there is shared. Except for the ones that you don't want to
Absolutely.
shared.
Yes, sir.
And that's one of the reasons we're here.
We'll make an additional inquiry to the lab to see if there's anything else in the form of emails that they haven't already provided to us.
I would add, there are times, okay, in the world of the law, that sometimes people forget to do things, or sometimes things fall through the cracks. And so it's always healthy to make sure that it's done thoroughly.
Absolutely. Thank you, Judge.
Thank
We're going to call Steve Mercer.
you. Okay?
Okay, so now at this point, they're going to bring up their expert witness. I want to skip over to this one right here that Long Cramp uploaded. Judge refused to delay Brian Kohberger's case, locks in October trial date. This one's only 50 minutes long, and I can't promise anything about the audio, okay? Well, let's listen. I'm going to speed it up to 1.25.
I guess we'll start with the state on the motion to reconsider the order setting time for speedy trial. That is also somewhat related to the second motion to stay proceedings. It was filed July 25, 2023. Why don't you go, Mr. Johnson? Oh, no, Ms. Beatty.
Thank you, Your Honor. Your Honor, we're asking the court to reconsider its order, wherein the court issued a limited tolling period, I guess, or stay, specifically for the purposes of extending the speedy trial period by 37 days. And we filed that motion mainly because we're just concerned about the record in this case, and we're concerned that where Mr. Kohberger has essentially stipulated to there being good cause under the statutory speedy trial statute, we're concerned that should he try to invoke speedy trial later, and should the state disagree with that, it could create a very genuine issue to be litigated and possibly on appeal. Now, in the defense's reply brief,
Oh, I don't know. Question: will this trial be live stream or will it be re-uploaded the day after? I don't know.
Response basically seems to be, well, he didn't waive his constitutional right to a speedy trial, and the state didn't argue his constitutional right to a speedy trial or bring that up because we don't think that there's enough there at this point. That's not to say that if the court were to apply that analysis, it would necessarily come to one conclusion or another, but that was the area of concern for the state, is the statutory speedy trial. And the statutory speedy trial issue is under Idaho Code 1935-01, which provides that a defendant whose trial has not been postponed upon his own application, that their case can be dismissed if they have brought to trial within 6 months. Well, what we had in this case is the defendant filed his initial motion to stay, basically saying, I intend to try to get this indictment dismissed. I don't know how yet, but if the court could just issue a stay and give me some time to figure it out under Idaho Code 2-213, then I'll have time to review the materials and find a way to attack this indictment. That's a litigation strategy. So if the court's response to that litigation strategy was to issue an order stating, well, this statute doesn't provide a basis, but I'm just going to extend trial by 37 days, our concern is that should the trial then get continued based upon the defendant's statement on the record that he agrees that there's good cause, that could really create some issues. It should also concern the court that the defense...
Sorry, I'm laughing because I'm reading your guys' message. I'm trying to listen to her. Beer. Beer's my favorite dish.
doesn't really argue the statutory speedy trial issue in a brief. They just say, well, he has waived his constitutional right. And I'm not... that should concern the court as well. Are they agreeing that he's potentially going to be waiving his right or creating this issue down the road if the trial gets continued? I think it's messy, and that's a concern as well. The other reason that we really like the court to reconsider this order is that this very short-term continuance of 30 days used as a tool to give them more time to engage in litigation strategies. It makes it very difficult to have some predictability for the folks who will be testifying at trial, and more importantly, who will be testifying at trial and who will be under subpoena for an extended period of time. If we're telling them, hey, we have trial set on October 2nd, but hey, it might be moved another 6 weeks, so basically walk out the next 12 weeks of your lives, and that puts them in a bind.
So again, this is just the same arguments that's made in the motions by the state. Defense wants to have a stay in the trial where they essentially, I think the judge gave them 37 days. So I'm just repeating myself over and over again, just in case anyone missed it. But a judge essentially was like, okay, well, I'll put in a motion to stay trial for 37 days. And the state's like, no, we don't want to do that because this could fuck with, victims' families. Well, not the victims' families, and anyone that's under subpoena to be testifying. Like, instead of having the 6 week that's blocked out of your life, from October 2nd to 6 weeks out, it might be another more additional weeks because they don't know when the trial date is actually going to start.
Certainly puts the court in a bind when it comes to trying to figure out how we're going to bring in a very large number of jurors if we're using this as a tool either once or maybe potentially more down the road. I'm not sure. And I think finally, and this is, I guess, the larger concern is the victims in this case. I certainly wouldn't want to put them on a roller coaster where we have short-term continuances of a trial where we get right up to the date and then it's, okay, well, we're going to move it, but it has to be done within the next 37 days. Because that psychologically, emotionally, and travel arrangements-wise, that is a very difficult position to put these folks in, especially folks who are loved ones of the victims who would be very difficult for them. So we would ask the court to take that into account as well, but really primarily the speedy trial issue and the potential for needless litigation down the road, potentially appellate issues. We would just ask the court to keep trial set on October 2nd, and only if the defendant waives speedy should the court move that trial date. We would ask the court to reconsider its order. Thank you, Your Honor.
Thank you. My understanding is that the defense wants to keep it at October 2nd. So I'm not going to kind of piecemeal it along the way.
Thank you, Your Honor.
I mean, the only reason I granted that in the first place is because they didn't have a right to get the grand jury transcripts and materials. They didn't have it yet, so that was the only way I figured to do that, to let them go through that material, which apparently they now have. So.
What did he say? So I think the judge said, like, oh, the reason why I granted the 37 days additionally is because defense has a right to the grand jury transcripts and the materials. They didn't have it at the time.
Yet, so that was the only way I figured to do that, to let them go through that material, which apparently they now have. So, all right.
I don't know what he said at the end.
Mr. Watson.
Okay, Mr. Watson.
All right, they're arguing. Let's go.
Okay.
Argue time.
So we obviously differ a little bit as to whether or not we found anything off with the way that the grand jury went in this particular case. And I don't think the state probably wants to move it into the nitty-gritty on that on the record, so I'll just correct the record in that we disagreed when we said that we needed to do some sort of a fishing expedition. We believe that we'd already brought to the court reasons why that statement could be issued. My understanding of the state's motion to reconsider is essentially saying there's something wrong with this order. My response was, there's nothing wrong with the order. There's nothing wrong with saying that there's essentially a pause on the right to speedy trial. Now the state says, well, what about the statute? Well, that's a different area of litigation. And we can start litigating it now. It doesn't seem right. So nobody has filed a motion to dismiss the case. This court hasn't even moved the trial date. And so if the question is simply, does the order per se the court issued, which essentially is sort of a speedy trial has been moved for however many days, that's not going to create some kind of litigation down the line. I don't know, even if the court somehow took it back, that would necessarily change anything, especially given our current circumstances. And I think, as the court's noted, nothing's actually changed in terms of when the trial occurs or anything else. And so, from our perspective, Your Honor, I guess we should say, I don't think this is right for the court to concern itself with. What does that mean in terms of statutory arrest and speedy trial? Is that something that we're going to have to litigate down the road? Maybe, but I don't know if it makes a whole lot of sense for us to get into that. As for the rest of the concerns the state has, I mean, right now, nobody's saying the parties are going to be ready to go. So, when somebody at some point does that, then the court will deal with it. So again, I would say a lot of these are hammering concerns that we're hearing. While understandable, I just don't think there's much the court can do about it at this point. Okay.
Well, 6 weeks away. I mean, we're all in touch. It's really challenging, no doubt about it. Everybody's ready for it. Great.
6 weeks is challenging, no doubt. Okay.
Okay, the response.
Response from the state?
I think just for, if nobody intends to utilize this order, I guess I don't see the harm in just rescinding it, so that you have some predictability as we're planning ahead. We've subpoenaed many of our witnesses. We're looking at making travel arrangements that would give us some predictability if nobody intends to utilize this order anyway.
Okay, so I think the defense saying that, like, hey, we probably aren't going to utilize, or the court's probably not going to utilize this extra 37-day order anyways. To see, it's like, okay, well, if no one's going to utilize it, we'll just rescind our motion and let's just, what the fuck were we fighting about then? I'm a little confused.
Seems like it would be a no harm, no foul situation to just withdraw it respectfully.
Thank you. All right, before we finish that discussion, I think we should just go to the motion to stay, the second motion to stay, and I think you're going to argue that, Ms. Taylor?
Oh, okay, so now we're going to argue the second motion to stay. Okay, gotcha. I've had Korean blood sausage before. It's pretty good. It's not my favorite thing, but it's pretty good.
Your Honor, I am going to be as intentionally vague as I can. This motion to stay is grounded in Idaho Code 2-13. This is a very narrow look and something that will justify the court staying proceedings while the court looks into it further. This has to do with juries, a trial jury or a grand jury.
Okay.
In our circumstance, we're talking about the grand jury. We're looking at if there was irregularity.
Oh, okay. So this is when the defense put in a second motion for a stay. And this is because, like, the basically the secret grand jury indictment, where they're like, hey, we don't know the process behind how you guys chose a jury, if they were even qualified to be jury members. On the form, it said this person said they didn't even speak English, and y'all chose them. I think that's what I remembered from reading the motion.
And how that grand jury ended up being the one that heard the case. We are looking at the way the panel was convened, how the individual jurors ended up being brought in. Was it a public setting where the public has polling or calling of these grand jurors. And were these jurors people that had not sat on other juries in that same county? Your Honor, one of the big areas that we recommend the court stay proceedings and look into is the impact on the number of jurors that were called. The number of jurors that should be brought into a jury, according to the statute, is going to be dictated by court order. In this particular case, Judge Gaskell, I believe, maybe Your Honor, issued the order for 45 jurors to be brought in. 32 were brought in. We don't know why.
Okay.
I can't find any record that tells me why that happened. But that's quite a few shorter than the court orders. And I think the court should stay proceedings and look into that.
Okay, so she's saying that, like, hey, you guys originally ordered 35 jurors to come in, but 45 jurors to come in, but only 30 something came in. She doesn't know why. She wants to look into it.
That matters. That matters because of things that happen within the grand jury. I'm not going to go into those now.
Okay.
Those are things that will become, if we can get an evidentiary hearing, we'll talk about those things. Those are also things we'll talk about when we challenge the grand jury indictment itself.
Okay, so they want to challenge the grand jury indictment.
But they matter. There's a reason a court orders 45 grand jurors in to appear to be chosen or selected to be the seated grand jurors in a case. And that didn't happen this time, and we don't know why.
Okay.
There are irregularities on the face of the juror questionnaires. There are some that don't indicate the juror number, the panel number, the wheel number. Those all have to have something to do with the public selection of the grand jurors or the calling and the seating, or they have.
So I just want to pause really quick because I'm just looking at Judge's body language right now. He's like, oh no, he's just like, I wonder if this judge was part of the grand jury indictment. I'm pretty sure, right? It's like the same judge.
That's brought out to those jurors from. I don't know why there would be differences on the face of those.
Why is Ann wearing a mask? If I was representing him, I'd wear a fucking mask.
Grand juror questionnaires.
Or maybe she's
did
not feeling
give
well.
Information. Some had all of it, some had some of it, and one had none of it, including a juror number. Some of those people sat on the grand jury that heard the case. That is an irregularity, and one that we should have an evidentiary hearing and understand if this was a properly convened grand jury to hear this case. Additionally, there are areas that have to be questioned of a potential juror. There are criteria and that.
Oh, it does? Okay, grand jury has a different judge. Okay.
In any
I'll look that up. I didn't know that.
grand juror has to meet. Some are the ability to read and speak English. Some are to not have a felony conviction that prohibited one from serving on the grand jury. There were irregularities on the face of those documents as well. The court should stay the proceedings and allow an evidentiary hearing to determine what, if any, impact those had on the grand jury indictment. There is another issue that was part of the sealed affidavit in the first motion to stay, and there are still questions about what impact, if any, that had on the seating of this grand jury. Your Honor, without going into the exact examples of things which I think constitutes an evidentiary hearing, we're asking the court to issue a stay in this case and allow us to have an evidentiary hearing and go into those issues more fully.
Your Honor, the Uniform Jury Selection and Service Act really just governs the process utilized by the court in bringing in a jury, in maintaining juror roles, and in regulating the court's processes. The Act sets forth some pretty specific criteria, but there's a lot of allegations that have been raised by the defense that don't fall anywhere in the Act. One of the things that they addressed were allegations of potential juror bias against the defendant. And I think that's what's really being referred to when we talk about a smaller number of jurors being called in than were summoned. But typically, at least in my experience, court summons in a large number of jurors, knowing that there are people who are going to be excused for one of the permissible reasons in the statute, and there's no indication that isn't precisely what happened in this case. Now, other areas that were brought up were irregularities on the face of questionnaires, specifically numerical information in the upper left-hand corner that was referred to. Again, that information is not required by the statute. There is nothing in the statute that requires a jury commissioner or a clerk to maintain that type of information. And in fact, if the court were to go to the Idaho Supreme Court website and pull the standard jury questionnaire form, none of that information is included on the form. So whether or not that was an internal issue with the clerk's office or the jury commissioner's office, it is certainly not an issue that would require the court to stop this case invoking 2-213. There were allegations about the way that some of these jurors filled out questionnaires. Again, I don't dispute that the jury questionnaires require certain information to be filled out, but it's not, the act doesn't compel jurors to do that or govern the jurors' behavior in doing that. Instead, the act sets forth the remedial steps that the court or clerk's office or jury commissioner's office is supposed to take when that occurs, and they haven't even made that allegation, nor have they asserted that there's anything in the other materials that give them reason to think that there were issues related to one specific juror who failed to check one of the boxes. Now, the other thing that came up in that motion was that there were jurors that the presiding judge, I believe, had praised some of the jurors.
Okay, you're right. Yeah, the presiding judge.
For a handful of jurors who agreed to serve despite having other obligations. Again, Your Honor, this is really, really stretching the purpose of the act. This conduct is not really forbidden by the act. The act does not prevent a presiding judge from thanking jurors for their service. This motion to state should be denied. There certainly has not been a substantial failure to comply that has been alleged. Arguably, there hasn't even been a failure to comply to the extent that these allegations deal with things outside of the act. We would ask the court to deny this motion.
I don't know if they would be fans, but there are some people that just want to be contrarians, or they're just like rage baiters. So they'll say something, just try to like bait other people to get really mad at them and stuff. So, I mean, there could be fans of him too, but I feel like most people are just trolling. Hey, gamer girl.
Yes, Your Honor. Idaho Code 2-208 requires that there be a public drawing for a grand jury. The jury commissioner.
Beautiful messy boss says grand jury is a completely different process and different court altogether. Imagine rage baiting. Kick. Yeah, you do that a lot too.
Is charged with having a random list of jurors and calling the jurors for them. I don't know what other information I could be in possession of at this point without an evidentiary hearing, other than the irregularity in the upper left corner of the grand juror questionnaires, all of them, all 32 of them. There are differences between both. I think that is probably how those are tracked, the random nature of those are tracked. But I don't know. There's not a mechanism where I am going to have that unless we have an evidentiary hearing. So pursuant to the statute, that raises a question. Your Honor, further the statute, the number of jurors was required and ordered by the court to be 45. All of the things that don't fit into the statute, the juror bias, the judge's impact on freezing jurors for staying that had other issues that were pressing them, those are examples of why it matters. We're not saying that there's a statutory subpart that says those very things. We're saying there was a court order for 45. There was a failure. There were 32 calls, and we think the court should find out why and if it matters. Your Honor, we provide examples of why it matters. Your Honor, in Idaho Code 2208 subtext section 3, the missing information. I believe that the form is supposed to be sent back to the juror. I don't know if that was done. I can tell you that there's things that are wrong on the face of those forms, and there's not an indication if they were sent back, if they were ignored. There's a process there, and if it's not done, that's a substantial failure. We're asking the court to please stay the proceedings of it.
What are your thoughts on Dev You Heard Netflix docuseries? I haven't seen it yet. I have not watched it yet. You tasted enough blood. I don't know if I could do a blood sausage, but at least tried once. It doesn't taste like blood. Blood sausage, I don't know. At least the Korean one that I had, you don't really taste the blood. Like if you have like some Southeast Asian soup dishes, they'll have like blood blocks. That one, you know, it's a little bit, I don't know. It tastes kind of like blood jello. I don't know how to describe that, but yeah. It's like tofu.
So one of the things that I'm thinking about is just how short the time is we have right now. I looked at the affidavits. It's pretty vague, I have to say. I looked at the case law. I looked at the statute.
Wow, they started at 10:30 and it's 4:30. I wish we could get like the entire footage like unedited.
And
Hi, Jesse.
I know that your team has looked over the transcripts and materials. You know that I believe Mr. Thompson was there. Was here the time. I don't have that advantage knowing what happened. I wasn't there. I haven't looked at this material. And based on what has been presented, I'm not persuaded that there is a substantial failure to comply with this Chapin.
Okay, so the judge sounds persuaded. He said he doesn't even know because he wasn't the judge there. He doesn't know what happened. Wait, so you're repainting your house? What? Oh my goodness. Have you ever painted a house before? Dude, I wish I could have my place repainted, but it's yeah, it's definitely like a higher type of thing. We got quoted like 10 grand and I was like, nah, I'm good. I'm okay.
I just don't see it. I think these are sort of some typical things that you see all the time with jurors. It's not unusual for a number of jurors that we ask to show up don't show up. I don't think it's that unusual. And so,
Okay, so judge says he doesn't think it's unusual for, you know, to request 35 jurors and only 30 something show up. Okay.
Concerns that Mr. Kohberger cites very well could have been corrected with some questions. I don't know. So I'm going to deny the motion. And connecting to
Okay, judge is going to deny the motion.
the earlier sort of order to allow the defense to get the transcripts, give you time to get the transcripts, to get the materials to the grand jury. I think that that purpose has been satisfied. That's the reason I wrote it down in the first place, to give you all a chance to look at what actually happened with the grand jury.
So they should get the transcripts or no?
At this point, not satisfied with the standard, finding a substantial failure to comply with the act. I'm going to roll back the original stay, and I'm putting in quotes because
You can't, Chopper. You already know too much about this.
it wasn't stayed under statute. It was just my idea to try to give the defense an opportunity to be able to file such a motion. After stay under the statute, I don't think this is that. So I'm going to deny the request to stay the proceedings under Idaho Code 2-213, subsection 2, and I'm going to roll back one prior order. As far as I'm concerned, we're starting the trial October 2nd.
You're on Storm Watcher Starcat tonight? Yeah, there's a YouTuber that's streaming. Well, not a YouTuber, but he's actually like a storm chaser. I think his name is like Reed Timmer. I think, is he still streaming? Dennis was watching him earlier. Let's see. Reed Timmer. I think he's live like right now. Yeah, Reed Timmer. Tropical Cyclone Hillary, Southern California tornadoes. Huge flooding likely. 18K viewers. I think Dennis is watching that right now. But I've heard of his name because I really got into like storm chasing like a couple years back. And there's this other guy that I watched, Hank Picos, which I don't think Hank is. Hank Picos. Wish we would do some live streams. All right, sorry. Distraction.
Jury selection. Right now, I think we have trying to put in 1,000 potential jurors. At this point, I'm not even sure that's it. That's what we're at.
Oh, maybe you're allergic to
so
soy?
Next motion, I believe, is the state's motion to compel notice of defense.
So the judge just denied the defense's second motion to stay trial proceedings. That was denied. Now we're going to talk about the alibi. Oh, the alibi, the horrible alibi.
Yes, sir. Thank you. And Judge, since filing of our motion looking at the defense's response, it looks like we've made a little bit of progress. The defendant has at least, Mr. Kohberger has at least now stated that his alibi is he was out driving around that night. We knew that already. And if that's his alibi, so be it. What the defendant has still failed to do is to comply with Idaho Code 19-519 and Idaho Court Rule 12.1 that specifically requires a defendant to provide identified names of witnesses who will be called to support the alibi along with their addresses. The defendant has only said, well, I may do that, or I may call witnesses, or I'll do it through cross-examination, and of course I have the right to testify on my behalf. We don't question that. At this late date, I do not believe it is possible, even if the defense were to provide a list of the names of witnesses and addresses today, that with everything else that needs to be done leading up to a week before October 2nd, that there's any way that the state could reasonably be expected to respond with the, as contemplated by the rule of statute. So the state's position at this point is we will accept what the defendant has said, that he was driving around, although he should specify where he was driving. If he's not going to call anybody else, if he's not going to offer evidence to anybody other than himself, then that's none of our business. So we're willing to accept that with an order from this court prohibiting the defense from offering third-party evidence, whether by direct or cross-examination, in support of the defendant's claimed alibi. If he wants to testify to that, that's his prerogative. But at this point, it's too late for the defense to comply with the statute and identify specifically people and their addresses who testify. So that's where we stand now, Judge. Thank you.
All right, clear and right to the point. You're north of San Diego County. We're set to take on some of the worst of it. Yeah. Oh, you're 4 miles away from shore. Be careful out there. Yeah. San Diego is where you guys are going to get, like, I think the level 4 hurricane. But by the time it comes up to LA, I think it's going to be, I heard it was going to be pretty weak.
Taylor?
Okay, Judge.
All right.
Your Honor, we provided to the prosecutor what we can provide to the prosecutor and more. I think that Mr. Thompson's right. We don't have to tell the prosecutor if Brian's going to testify or what Brian needs to say. We have indicated that that it's possible that we would have additional things that might come out through expert testimony and cross-examining the state's expert. I don't have documentation to give to the state today. I am not going to go into...
Look at how intently he's staring at her. They've given Kohberger's alibi, but what they haven't given to the state are the witnesses that are going to corroborate with that. And the state's like, we need that. Like, hello, ASAP, give it to us.
Any more of that at this moment. I understand when October 2nd. I definitely understand that. And I've heard everybody's thoughts and concerns. I get that. But I mean, this is what we have, and when there's more, I will tell.
Your Honor, with all respect, that is exactly what the rule and statute are designed to prohibit. As the U.S. Supreme Court observed in Taylor v. Williams, the ease with which an alibi can be fabricated. The defense is waiting to gather up evidence, seeing what they can fabricate to match that evidence, say, oh, by the way, here's alibi now. That is specifically what's prohibited by the statute, by the rule, by the comments of the U.S. Supreme Court, Williams v. Florida. You know, trials are not yet a poker game where players enjoy an absolute right to always conceal their cards in full play. And that's what's going on here.
like how Murdoch changed his alibi a little bit and was like, oh, you know what? Actually, you're right. I was down there at the kennels. Oh, I guess I forgot. I forgot that I was down. Okay, sorry.
That's why the rule exists. Just need to cut it off and we'll move forward. The defendant can testify to his own alibi if that's what he wants to do. But it violates the rule, the statute, and the rights of the state to a fair trial to allow third-party evidence, whether by direct or cross.
Oh, I'm sorry. I keep like scratching myself because last night I woke up in the middle of the night and there was a fucking bug crawling on me and I freaked the fuck out, dude. Oh my God. I had to take the bug and put him outside, but I was like laying in bed and like I woke up because I felt something like tickling my arm and I was like, oh, what is that? And I felt tickling my arm again. Oh, that's why I could still feel like the bug crawling on my skin. Oh, okay, sorry.
Well, the way I understand this is, and this is in the so-called alibi, not really an alibi, quote, he was out driving during the late night and early morning hours of November 12th to 13th, 2022. So what I'm going to do, because the next motion is for a scheduling order, I'm going to address this in terms of the deadline. And we'll see how that goes. Right now, that is as far as Mr. Kohberger wants to go with regard to alibi. If there is going to be, Ms. Taylor, you suggested that.
But there are people who don't read newspapers. There are people who aren't tuned into the news. Like, people that I know don't know anything about this case. But we are in California, though. Like, even like California cases, right? Let me think. Is there anything that happened recently? There's just some people who just don't read the news. They don't follow true crime stuff at all. So they for sure will be able to find someone.
Some witnesses, certain date, certain I I read the Albert case, which was interesting because they were independent witnesses. The judge refused to allow them to testify, and that case. Yeah, I know. Maybe it was both. Then there's Perez. That was 2021. That was a court of appeals, and they said not allowed to vote. And so, Ms. Taylor, you acknowledged that potential risk to your client who made his response to the request. So there's some potential balance.
Hey, Paris.
Constitution of the United States. All right, so.
Right, but not everyone's in each other's business. Though. There are people just mind their own business. Was it a bed bug? No, it wasn't. It was like a little roly-poly or something. Or I thought it was a spider, but when I captured it and I let it out, it looked like a roly-poly. But I don't understand how roly-poly would get all the way up there. I don't know. I was like fucking half asleep, but I was like, just chucked it out.
I think that takes care of that for now. So I can give you deadlines. So I think the last motion then, again, this motion to dismiss indictment has been pushed out.
Leslie, I don't know who that is. Who's Leslie Houghton?
I don't think we haven't said it yet, but we will talk about that. But there's a motion for scheduling. Absolutely, we need scheduling. Okay, I don't dispute that. Didn't do it earlier because we were dealing with other things, thinking possibly this case is going to be pushed out because.
Oh yeah, Paris. This is the Idaho students university murders. So back in November, 4 students were murdered in their home, and it was like a shared home with like other students as well. And so they were stabbed to death, and he is the main suspect in this case right now. The trial is set for October at the moment, and we're just doing some like pretrial stuff right now.
There were so many
The germs.
I understand that.
Oh, I do know. Oh, yeah, I did hear about Leslie Van Houten. Yeah. One of the Charles Manson family members. Yeah, I did hear about that. Yeah, how long was she in jail for?
Kohberger is anxious to have this.
How old is she now?
So I'm going to tell you, this is a little bit of a reality check. I'm just going to tell you what the schedule is. Okay?
All right, reality check.
So you'll be able to see it. So 6 weeks, about 6 weeks away from trial. And I'm going off of Mr. Thompson's motion, maybe added a couple of things, but deadlines for completion of discovery, September 1st. Deadlines for expert disclosures under Rule 16b7 and C4, September 8th. If there is an actual alibi, then it's
If there's an extra alibi. Interesting emphasis.
required under Rule 12-1 and 19-519, September 8th.
Okay, so September 8th deadlines we got so far. September 8th, that's like what, 2 weeks? More than 2 weeks? That was 3 weeks. Oh, that's actually 3 weeks exactly from the day that this was streamed. So 3 weeks for the experts and 3 weeks for the alibi.
Deadlines for pretrial motions.
Pretrial
including
motions?
Motions in limine, motions related to the death penalty, and other motions under Rule 12b. And I'm going to say also, if your client, Ms. Taylor, decides to waive speedy trial, I'm going to have a deadline of September 8th. Because there's going to be a lot of work between now and October 2nd, and if that is in fact what's going to happen, and we want that
Okay, and if Kohberger wants to waive speedy trial, September 8th.
to happen earlier than later. Deadlines for responses to the motions, September 15th. Deadlines for proposed jury questionnaires, September 15th. Deadlines for proposed witnesses under Rules 16b6 and C3, September 15th. Deadline for any Rule 404B notices, September 15th. We'll hear all the motions And I'll clear out the whole day, September 22nd at 10 a.m.
No, his alibi was that he was on a long drive, doesn't know where, doesn't know what time exactly, but he likes to take long night drives.
I'll call it first steps for death penalty qualified jury selection. I'm carving out September 25, 26, and 27.
Wait, I need to write this down. Okay. Not really quick. So we have for what the fuck. All right. So Kohberger trial. September 8 deadline, and then we have September 15 deadline for responses to motions, jury selection, questionnaire. Was that what he said? Questionnaire stuff. September 25, 26, 27 for jury selection, I think.
I don't know if that's enough. We'll see. Final pretrial conference, September 29 at 10 a.m. Trial, October 2nd, starting 8:30 through November 17th. This is a tight schedule.
Jesus. I mean, I knew this one was going to be a long one. So October 2nd to, they said November 17? October 2nd to November 17 is how long they expect this trial to be, right?
Through November 17th.
Yeah.
This is a tight schedule. You all know it. But we can do it. That's what everybody wants. I'm up for it. But I'm going to clear out the deck for September. And so there may be other things that come up, including do you want to set a hearing on the motion to dismiss the indictment at this point?
Your Honor, we should set that for hearing, but we have an additional motion to dismiss the grand jury indictment for various different grounds that's having been filed yet. I think it's since have both of those motions for discussion.
Absolutely. When do you want to do that?
Sometime probably 2 to 3 weeks from now.
3 weeks. Here we go.
Oh, he's soaked. Oh, poor Bubby.
Two to three. Not next week. Do it next week.
I cannot do it.
I am.
Yeah, no, when I was a teen in like my early 20s, I used to do the same thing, like just like do like night drives as well. But, you know, being accused of murder, no, it's a really shitty alibi to have.
Exactly. Because I'm trying to clear everything out. Okay, so actually, we could do it the afternoon of September 1st because I had that at one point. We're going to have September 1st, that's a Friday. Say 1 o'clock.
Judge, we're going to need time to respond to whatever other motions they're going to file. So we're going to need a due date for them with a reasonable amount of time for us to respond to any additional grand jury attacks.
When can you file?
I think we can file it probably by midweek.
Midweek,
Wednesday.
okay, August 23rd.
Yes.
Okay, let's say August 29th for a response. Is that, I mean, we're on a tight schedule.
Understood.
Does that work? And then we can still do September 1?
I'm wondering if maybe it would be wise to put it out. We've got a bunch of things going on the 8th, just do it on the 8th. Oh, Mr. Nye isn't available. So if it's about grand jury, we need Mr. Nye.
He's not available, what, September 8th or
Yeah,
September
what I was proposing.
Your Honor, 6, 7, and 8, I'm not available. I think we could probably do it. I guess my question is just how long is this? Not like 400 pages? If it's one of those, I'm not going to be able to respond in a week. So,
Oh, please do not give me a motion of 400 pages, please. I don't have time.
It's not 400 pages, Ron.
What is it?
You're not 400 pages.
Okay.
Well, yeah, that may be kind of an overstatement. The motions that we've seen on some of these issues in other jurisdictions are multiple pages, as the court can see from the one that's pending.
Yeah, I don't know. I was thinking like maybe he was going to say that, yes, he does own that car, but maybe he was hanging out with someone and maybe someone else drove that car. Maybe that car was stolen for, that day and he got it back and he found it on the side of the street somewhere.
Dozens of pages of attachments that are taking us back into ancient history. Realistically, the court's got the same amount of time as we do to try to digest all that.
And I wonder if they can do what the Murdoch case did. Remember how they were able to contact GM and get the car data? So I wonder, I don't know how old his Kia was. Was it like 2015, 2016 or something? I don't think it was like that old. Maybe there's some data on there that they can download.
Plus, we have to respond.
I've read every single report.
Yes, sir. We've been there.
So, can we do it on September 1st? I'd like to clear it out. Hey, if I'm going to dismiss the indictment, I think everybody should know that pretty soon. Also, if I deny it, everybody should know that pretty soon.
And I think our concern, Your Honor, is just we're talking about a potentially very lengthy brief being filed sometime next week and then a deadline the following Tuesday. I think that the brief deadline, is potentially more concerning than the hearing date.
Okay. So you want a little more time to respond?
Well, I think they should have a deadline and then perhaps at least a week for us to
Well,
respond.
their deadline is August 23rd.
23rd, okay.
Yeah. So,
If we-
I'm trying to accommodate everybody, trying to make everybody happy.
Hey, Juice, what are your thoughts on it? I haven't seen it yet.
So, Your Honor, if we can have till the 30th, then I'll just, whatever it is, I'll respond to it in 7 days.
Okay. So you could respond by August 3rd.
I'll do my very best, yes.
Okay.
August 30th.
Can't ask more than that. You say you're not available September 6th, 7, and 8?
Correct, so if we respond by the 30th, and then we can do the hearing 2 days later on the
We'll make it work, Judge. I'm just trying to be out, but I'll change that. That's not a problem.
Okay.
According to my calendar.
I'll make it work. 1 o'clock, September 1st?
Yes, sir.
Okay. Keep the lines of
Okay, so here's what I got so far. August 23rd is going to be the deadline for the defense to file the motion to dismiss a grand jury indictment. August 30th, which is 7 days after that, the state has to respond by then. September 1st is when the judge will make their decision. They're going to meet up. September 8th is going to be the deadline for any expert testimonies, Kohberger's alibi, and whether or not he wants to waive his right to a speedy trial. September 15, a week after that, is going to be the deadline response to those motions and the jury selection questionnaire. 10 days after that, we'll have jury selection. 2 days after that, we have a pretrial conference. And then beginning of October to November 17, potentially the trial. I hope I got that right.
communication open, okay? Be respectful to each other, and maybe some of this.
When you say be respectful to each other?
And just to clarify, Judge, on the September 1st deadline for discovery, that includes also all litigation and sentencing evidence. Is that correct? It's all one and the same. Once we get to one trial, there's not going to be another break.
Well,
I just want to make sure that the defense and we are clear that that's the line being drawn. I don't want to get involved up in some
Right.
after the fact saying, oh, well, for purposes of sentencing, we want to call this expert and this mental health person and these family friends and all that sort of stuff. That's not going to be appropriate post-time trial starts.
well, figure out, I think this is what was discussed when we decided October 2nd, is that the trial would be 4 weeks and then the sentencing would be 2 weeks. If he's found guilty. That's
I believe so.
all right. So during that period of trial, I mean, remember, I see a whole bunch of lawyers here, maybe period guilty.
What did he say?
I believe so.
All right. So during that period of trial, I mean, remember, I see a whole bunch of lawyers here, maybe
Sorry, he's just something else.
figure out, I think this is what was discussed when we decided October 2nd is that the trial would be 4 weeks and then the sentencing would be 2 weeks.
Trial 4 weeks, sentencing 2 weeks. Got it. Okay.
Guilty.
I believe so.
Alright, so during that period of trial, I mean,
That's realistic, Judge. This case is complicated. I think it's going to absorb the efforts of all the attorneys that are standing before you right now, just on the issue of guilt. And the state, of course, needs to have time to react. The defense is going to disclose sentencing experts, is going to disclose possible things about background, mental condition, those sorts of things. Those are complicated, lengthy endeavors for us to respond to, including the possibility of having to retain other experts to rebut whatever the defense Ms. Kohberger wants to offer. And I think
He does not look like Santa Claus. Santa Claus is. Okay, Santa Claus, that was kind of good. I cook sick for all of them and spoil them rotten. They give us so much love. Oh, are we talking about the bubbies?
if we're realistic about this timeline, we need to suck it up and be realistic about everything. That includes the defense obligations.
I mean, if anything, he kind of reminds me of the guy from Home Alone. Do you remember in Home Alone 1, there was a neighbor that Macaulay Culkin thought was really creepy, but the neighbor ended up being really nice and awesome? I don't see the Santa Claus thing, okay? This is a fit-looking guy.
I would have a question about rebuttal witnesses for the state, rebuttal experts for the state might call. Disclosures, but I understand what Mr. Thompson's saying. Litigation is a huge complicated piece of every single capital.
I understand too.
The street shoveler. Oh, yeah. Snow shoveler.
And, I have no idea what you're
Oh my God, there's an earthquake right now. Oh my God, it's a pretty big earthquake. Hold on. Cheryl says he's okay. I don't know. Or my desk is just shaking. Was there an earthquake? It's still shaking. We gonna die? You Cheryl? You okay, buddy? You Cheryl? I did feel that. Oh my God, we're getting earthquake and a hurricane at the same time. Okay, Cheryl says he's fine. You stay with me, okay, Cheryl? Oh my God, what is going on? Hello?
You feel an earthquake?
Yeah, I have you on stream right now. Where are you?
Oh, I told you I went to go to UPS.
Oh, you already went?
Yeah, well, I'm going right now.
Oh, I just went to go get Shiro. I don't know if he felt it though. He looked like, or maybe he did. He felt like he was kind of discombobulated. Yeah.
How bad was it?
I was just sitting here and I just see everything shaking. I mean, it's probably it was just shaking, you know, but not like like not violent.
I see.
Okay, all right. Well, drive safe. I don't know. Be careful for like falling trees and shit, man.
Oh, yeah.
Yeah, or like bridges, you know.
Yeah, that's true.
All right, bye. What the fuck, dude? We're in Los Angeles. Where'd you guys feel it? Holy shit! Eee! You're north in San Francisco. It was a 5.5. Wait, what is going on? Los Angeles earthquake. Oh God! I'm scared. Los Angeles earthquake. Where do you go for earthquake times? Jesus. Ugh. Los Angeles earthquake. I don't think it's been reported on Google yet. Oh, LA QuakeBot. Is this it? September. No, this is old. Where do you go for earthquake? Los Angeles earthquake. Now. Oh, here it is. Oh, okay. This is in Ojai, magnitude 5.5 at 2:41 p.m. Ojai. Oh, I've never been to Ojai before. I heard it's really pretty there. I mean, the aftershock sometimes could be even worse, right? From what I've heard, you're sitting on the toilet, so you felt it. I don't like earthquakes. USGS is good at earthquake data. What the fuck, dude? Oh, man. Hi, Storm. Sorry, I'm like... I'm tell my siblings. Dude, what the fuck?
Busily working, Your Honor, very busily working.
Ugh, I feel like I'm gonna throw up. I don't know. I feel dizzy.
I would suggest that maybe there could be a little more time for that. I mean, the deadline for sentencing, mitigation, all that, make that September 15th. Because there's going to be a lot to put together by September 1st. That's just 2
Yucca
months.
Valley.
2 more weeks, but it's 50% of the time, less than 50% of the time before we're going to be in this courtroom taking a hearing, and we're going to have time to work on anything else. And, and once we get disclosure on their experts, we're going to have to disclose our rebuttal. And maybe we need to put that date in there. If we make all the discovery, including mitigation discovery due by the 1st, then Your Honor could have a date for rebuttal, a reasonable time after that, and still before trial.
So witnesses, that deadline is September 15th, is that what I said?
No, discovery, well, let's see. Let me look. Witnesses September 15th, discovery by September 1st. And so if there are reports from experts, from examinations, mitigation studies, and that sort of thing, those would have to all be by September 1st.
Your Honor, you made September 8th, the experts.
Yeah.
Along with several other things.
So you can have response to experts on the 15th.
Thank you.
So maybe we need to move up the deadline for witnesses on the same day.
Okay, I think that's it. I think that's it, right? We think we good? All right, I think we're good. We have our dates, and that's it for the Kohberger motion hearings. like shook it up. I don't live in California, okay, so I'm not used to these stupid earthquakes. Or I wasn't born and raised here. I'm scared of earthquakes, man. I don't want to be crushed underneath a building for days. I don't know.